Major breaking news. The United States Court of Appeals for the Ninth Circuit out of California and Hawaii have issued a major quote-unquote sensitive places decision in a preliminary injunction context, deciding which areas a concealed carry permit holder is allowed to carry guns in Hawaii and in California, notwithstanding the fact that there are certain laws that have been enacted, sensitive places laws, that are really government-mandated gun-free zones. We're going to break this down for you really quick in this video. There's some overall positive news because it was absolutely terrible anti-gun panel. And the fact is there are some Second Amendment victories in this decision. We're going to talk about it and what's next when we come back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the U.S. Supreme Court Bar, and author of many best-selling books, including Israel Disarmed, What the 10/7 Attacks on Israel Teach Americans About the Right to Bear Arms. Do not miss out and learn about the mistakes the Israelis and Jews made so we do not make them here in the United States as American citizens. Very important stuff in the book, Israel Disarmed. Check it out on Amazon. All right, folks, so major decision. This is the Reno May case. A whole list of people or other plaintiffs. You had the Firearms Policy Coalition, the Gun Owners of America, the California Rifle and Pistol Association, the Second Amendment Foundation, and so on and so on. All the major gun-related groups out there in Hawaii and California had a piece of this case. This was a motions for preliminary injunction both in Hawaii and in California against those states' laws dealing with quote-unquote sensitive places, which is a euphemism for government-mandated gun-free zones. Now, this was an absolutely terrible anti-gun panel. This three-judge panel in the Ninth Circuit Court of Appeals was terrible. I thought there was an excellent chance we would lose everything. But the good news is, the silver lining here, is that we actually won on some topics, which is a huge victory, that we won anything given the nature of this panel. But we did lose a bunch of stuff, and I will just tell you overall, the quality of the legal work by this decision was, I would say, at best, mediocre. Really, probably more along the lines of poor. There was no rational basis, in my view, as to how they drew lines as to what is allowed to be a sensitive place under the Second Amendment and what is not allowed to be. They really engaged in reasoning that would be more akin to what I might see someone in college do, and not even like a high-end law student. Nevertheless, they basically did the best they could, given the fact they probably don't like guns, and they're in the Ninth Circuit, and they don't want to work that hard, is my guess, on figuring this stuff out. So let me tell you what we won on, what we lost on. Let me tell you what the next steps are going to be, in my view, and what I would recommend. And then I'll make a couple of general observations about sensitive places cases going forward, and we'll go from there. So to begin with, let's talk about the good news. What did this three-judge panel find could be enjoined, meaning what sensitive places laws in California and Hawaii did they say violated the Second Amendment? Here is the list of what we won on. We won that financial institutions and their parking lots cannot be sensitive places. Parking lots shared by government buildings and non-governmental buildings cannot be sensitive places. Hospitals and similar medical facilities, no sensitive places. They're not allowed. Public transit, not sensitive places. Gatherings that permit or require a permit, again, not necessarily a sensitive place. Places of worship, sensitive places, no can do. We won on that one as well. And the default no carry rule in private places in California, this is the so-called vampire rule that says you're not allowed to carry anywhere on private property without first getting the permission of the owner. That was a win as well in California. We'll talk about the Hawaii one in just one moment. Now, what's weird is what they tried to do as to how they drew these lines is they talked about and they mouthed the words of Bruin of the standards for how you handle a Second Amendment case, which is text first, burden shifts to the government to show. Is there a long-standing historical set of analog laws to show some sort of historical tradition of regulating guns in a particular place? They then talked about some historical laws and the fact that 3 laws are usually not enough, and that outliers are not sufficient, that territorial laws from the late 19th century were generally speaking no good according to the Supreme Court. So they mouthed the words of a lot of good stuff. But but in their application, they were really all over the place with no clear rational line for ordinary people to know what is allowed and what is not allowed under the Second Amendment. And of course, that's kind of important if you're an appellate court to really lay out the law in some way that people know what's allowed and what's not allowed, and there's clear black and white rules and lines. That's a big part of the law. And they really didn't do that. It was really more of an ad hoc, this seems okay, this seems not okay, this seems okay, this seems not okay. And I think the way they kind of did it was this. They said that if these kinds of laws had existed at the time of the founding in 1791 and there were regulations on it, it was fine. If there were no regulations on it, it was not fine. But then what they did is if there are new laws of new gun control laws that arose after the time of the founding or more modern laws and there's no founding era precedent, then they basically say, well, how are these laws treated at the time they were enacted? Now, that doesn't make any sense because laws that could be enacted for the first time now, you wouldn't look to understand what the Second Amendment means today. You would say, what did the Second Amendment mean in 1791 and apply it today? So again, that's kind of how they did. They basically said if places existed at the time of the founding, what types of restrictions were there at the time of the founding? And again, if they're brand new restrictions or restrictions that did not exist until the late 19th century, then they would look at the way the late 19th century laws treated these. This is obviously sloppy, ad hoc, and not appropriate. The way you're supposed to do it is you look at the law of the Second Amendment, the Bill of Rights at 1791 when it was enacted by the people that enacted it, and ask yourself what was intended and what were the principles at that time, and then apply those principles today. And the clear principle that was unequivocally rejected by this three-judge panel, and I think the principle I'm about to articulate will be accepted by the Supreme Court at some point down the road, is the comprehensive security notion, that what set apart the courthouses, the polling places, and the legislative chambers at the time of the founding is they all had comprehensive security. They had armed guards there. And of course, when you dealt with courthouses in the 18th century, they had armed bailiffs. When you were dealing with legislative chambers in the 18th century, they had basically sergeant at arms with guns, and polling places were patrolled by armed deputies and sheriffs and the like, and constables. So at the time of the founding, they all had armed security. When they were going to deny you the ability to have guns, they provided the men with the guns for you, and that is clearly the right answer as I see it. All this other stuff is just, again, you're literally just throwing darts at a wall, and that is not going to be acceptable by the Supreme Court. Now, let's discuss where we lost next. So this court then went on and said, I've already went where we won. The good news now, let me give you the bad news, and you can see just kind of the absurdity of all this. This is where we lost, meaning they upheld the sensitive places law. So even if you have a concealed carry permit in Hawaii and or California, you're not allowed to carry guns in the following places. We lost that you can't have guns in bars and restaurants that serve alcohol, which is kind of weird because at the time of the founding, they had alcohol in bars, but set that issue aside. And you could have guns at bars and restaurants at the time of the founding, but obviously, who knows what this courts are thinking, not thinking that hard, obviously. Nevertheless, we lost the bars and restaurants that serve alcohol point. We lost beaches, parks, and similar places. We lost playgrounds. We lost youth centers. We lost athletic areas and facilities. We lost casinos and similar gambling establishments. We lost stadiums and arenas. We lost public libraries. I mean, come on. What is wrong with these judges? Terrible. We lost zoos. We lost museums. And we actually, believe it or not, lost the default vampire rule, no carry private property rule in Hawaii. But we won it in California and not Hawaii. Hello? Inconsistency much? What is going on with these courts? Anyway, and we also lost parking areas associated with places where guns are validly banned. All right, so that's where it stands. Now, again, you cannot have a constitution that says that the no carry default rule is constitutional in Hawaii, but not constitutional in California. This is absurd. This means it's not the law. You're looking at the rule of men or the rule of judges or black-robed mystics and not the rule of law. So again, this really just goes to show you that this court did not grapple with the hard question of where are the lines. And again, if you look at the time of the founding, what made the three sensitive places identified by the U.S. Supreme Court in Bruin, what made them all consistent with each other is they all provided comprehensive security. The polling places at the time, the courthouses, and of course the legislative chambers. That was the thread that holds those three examples together. at the time of the founding. Now, these places that I've just identified, none of these have comprehensive security. They're basically just putting up a sign that says gun-free zone, but they're not supplement. What they're supposed to do is, if you're denying you the ability to carry a gun, the only way they can do that legally, in my view, is if they provide the people with the guns and the security to protect you in the same way, metaphorically, as when they arrest you and they put you in the back of a patrol car or they put you in prison, they are taking over your body. And in that instant, the general rule that police and government have no duty to protect you against criminal behavior is changed, because when they take over your body, they're taking over control of you. They're disarming you. At that point in time, if you're their prisoner in the back of a police car or in prison or whatever, in custody, they now have an affirmative duty to protect your life. And I think the metaphor or analogy works exactly the way it does, not only historically, because that's what happened at the time in the 18th century with armed security, and it works today, objectively speaking. If they're going to take away my right to keep and bear arms to protect myself, the only way they can constitutionally do that is if they're going to step up and take on that responsibility and provide men with guns to protect me in the same way they would in a prison or in a police car or in a police cell, right? Or in a jail cell. So that is the harsh reality of this. This court did not grapple with any of this. They literally were like throwing darts against the wall as I see it. And again, now, with that said, let me be very, 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 very clear about what I think should happen here. This decision was on a preliminary injunction basis. Let me tell you what I would not do. You absolutely, if your lawyers handle this case, in my opinion, you should not seek cert from the Supreme Court. It is a waste of time. It is a waste of money. It doesn't do no good. Because we know the Supreme Court is not going to grant cert in a Second Amendment case on a preliminary injunction interlocutory appeal basis. And that is what this is. This is not a final judgment. This is on a motion for a preliminary injunction. Do not seek cert to the Supreme Court. You will be wasting your money and your time, and we will be wasting time for the Second Amendment, which could be better spent in other ways. Nor do I think you should waste your time going to seek en banc review for this in the Ninth Circuit, because all that will happen is the anti-gun Ninth Circuit will take this as an opportunity to sit on this case for the next 3 years and then decide it, and then you're not going to be able to go seek cert at that point because it will still be on an interlocutory basis. Do you see what I'm saying? If you seek en banc review from the Ninth Circuit on an interlocutory basis, when they issue their decision denying en banc review, in like 2 years from now, it will be denied your preliminary injunction on an interlocutory basis, which means a year or two from now, when they deny your en banc request, you're still going to be interlocutory. You're not going to be able to seek cert then. So it will delay things even longer. So the right answer, in my view, is take your lumps, just move on, go back down to the federal district court, and either win or lose as fast as you possibly can. Get back up in front of the Ninth Circuit on a final judgment as fast as you reasonably can. But do not mess around with seeking en banc review or seeking a cert petition. It is a waste of time and money, and it's just a bad strategic move all the way around. Now, again, what you guys do is up to you, but I'm letting you know, unequivocally, this is clearly the right answer. And if anyone disagrees with me, feel free to share it with me in the comments or on X at 4Boxes Diner. But the odds of me being wrong here, not high. That's all I'm going to say. All right, folks. Well, hope you learned something here today. We will certainly keep you apprised as this case develops. I probably will do a deeper dive video at some point in the next week or two. There's a lot here. We will do this. And again, make sure you follow me on X at 4Boxes Diner. And we will see you again very, very soon, I hope, here at the 4Boxes Diner.
Orders up. Table 2A.